Hi, Wayne, we good to go?
Yeah, ready when you are.
Now the recording has started, yeah.
Morning, everyone. Wayne, you're good to go.
Okay, thanks, Shazia. Good morning, everybody, from a bright and sunny Nairobi this morning. I'm based up in at APA offices, which is a whole large shareholding company in Nairobi with my colleague Anthony. Today, we're going to talk around directors of offices and the legal landscape in which we're operating these days. Just to start off with, in terms of the presentation, obviously, just to sort of talk around iTOO as a company. Are we on the shares of the things being shared at all? There we go. Perfect. Thank you. Yeah. As you can see from this slide here, we are based in a number of offices in and around predominantly Southern and East Africa, but also in Ghana and West Africa as well. The reason for this, obviously, we follow the hollow footprint around offering our specialist services that we do from an iTOO perspective. And the difference that we do, perhaps that other companies don't do, is that we have, such as myself, a local representation in each office to understand compliance issues, regulatory issues, changing market conditions, so that it's not a one size fits all. The products we offer are adapted to meet the local needs and requirements. But DNO is one of those areas where obviously there is a definite need or a definite change in legislation. In terms of the lines of business we do at iTOO, as you can see here, it's not your conventional covers, it's more specialist areas, the art and entertainment, such as event liability and commercial dealers and art for your high net worth individuals, your commercial cyber offering, your professions such as medical malpractice, PI and DNO, which I'll come back to just now, your casualty lines such as your broad form liability, trustees and commercial crime, and then your speciality areas such as recall, environmental, drones, bonds, aviation, renewable energy, which is obviously a big factor in the African market generally. And finally, from a global crisis point of view, the kidnap and ransom, and then political violence and terrorism. To come back to the DNO side of things, obviously this is a market or an area where there is a constantly changing legislation, and it's in most countries almost a compulsory purchase now for directors of offices to cover themselves and their senior management team in the event of them being held accountable by their stakeholders. And to give more detail on that, I'm going to pass over to my colleague in South Africa, Sadia. Sadia, take it away.
Good morning, everybody. Thank you so much for joining us on this cold Tuesday from South Africa. Wayne, thank you for the intro. I think you've set the scene on what our discussion is going to be about today. And keeping with the theme of Africa Month, we are seeing more commercial and economic development across the continent. New initiatives like the African Continental Free Trade Area present opportunities for cross-border business, and these are expanding rapidly across the continent. So with this growth, however, there are the risks that come with it. And, these present increased complexity and legal exposure, particularly for those who are involved in the actual transactions, which are the directors of the companies or the institutions entering into these trade agreements. Directors and officers, they are finding themselves under increased scrutiny. This is due to heightened accountability in the regulatory environment and commercial risks as they evolve in business. In South Africa, directors and officers bear a significant burden of responsibility and liability for their actions, specifically with respect to the decisions that they make as management. They are expected to act in the best interests of the company with due diligence, and they can be held liable for breach of these duties. The overarching legislation which we have in South Africa is the Companies Act. This dictates the duties and liabilities of directors. So prior to the Companies Act, the duties of directors were governed by common law. And this essentially said that they need to act with the utmost good faith, skill, and due diligence to promote company success through their actions. And then failure to perform these duties in line with common law would have rendered a director personally liable or to pay monetary damages. The Companies Act now codifies common law, and it makes a few notable additions, including the standard of conduct, which is something very important, as you will see through our discussion, directors' liability, as well as their liabilities to third parties. So when we speak of conduct, it extends more to a director just acting honestly and in good faith. It requires the directors to perform their duties to a certain standard. So the reasonable assumption of a shareholder in a company, for instance, is that every director will apply their particular skills, their knowledge, and their intelligence to the advantage of the company. Sipa, can we go to the next slide, please? Thank you. So directors and officers face potential liability for their management decision, as I've mentioned. And these can stem when they perform certain wrongful acts. This includes breaches of their fiduciary duties, negligence, and non-compliance with regulations. This is why it is essential that those in this kind of position have indemnity under our directors and officers liability policy. But how do we define what is actually a wrongful act? And as in all cases involving negligence, the test in South African law is essentially an objective one. It means the reasonable man test, and in this instance, it would be the reasonable director test. So how does the DNO policy operate? It indemnifies an insured person for an actual or alleged wrongful act. We then look at the capacity in which that person acts, the circumstances of the matter, and does it satisfy the definition of a claim? It must be noted that coverage under a DNO policy is typically subject to certain key exclusions, particularly in cases of dishonesty, fraud, or willful conduct. And further to that, the DNO policy is not a pursuit policy. So what I mean by that is it doesn't work for a director to institute civil or criminal action against somebody that they feel which has wronged them. It is to provide indemnity and, for example, legal defense costs where they are being accused of doing something wrong. So I'm just going to touch on a few case law examples, some very famous ones which highlight what I've mentioned about conduct being very important on the part of directors. So the South African Airways case, it was highly publicized regarding the conduct of directors and what impact it has on a company. And where that company performs poorly due to dishonesty, recklessness, or gross negligence of the board, the individual directors can be held jointly and severally liable for breaching their duties under the Companies Act, and in the case of state-owned entities under the Public Finance Management Act. So the plaintiffs in this matter, they submitted that the chief executive at the time, Dudu Miani's alleged conduct and her failures during her tenure as a director and chairperson of SAA brought the company into disrepute. They alleged that she was grossly negligent and in breach of her fiduciary duties, and they further sought relief in framing of a court order declaring her to be a delinquent director. So a declaration of delinquency essentially means that a person is automatically disqualified to act as a director for a minimum of 7 years, subject to the court's review. However, in this case, Dudu Miani was declared to be a delinquent director for life. The next one is Delta Property Fund Limited versus Nomvete and others. This case stemmed from a forensic investigation into financial irregularities at Delta Property Fund. It was a prominent real estate investment trust. The plaintiff, which was Delta, alleged that its former chief executive, former chief financial officer, and former chief operating officer all engaged in misconduct that resulted in substantial financial losses for the company. And this included improper transactions with third parties, breaches of fiduciary duties, and fraudulent financial dealings. The court in this matter, they found that all three of these directors had grossly abused their position and had caused severe harm to the company. Another very famous one in South Africa, well, not really in South Africa because this had quite a global footprint, was Steinhoff. The CEO, Marcus Euster, and his friends engaged in transactions aimed at enriching themselves whilst defrauding the company and its shareholders. And to do so, they used a global web of companies, including notorious tax havens such as the British Virgin Islands. A forensic investigation by PwC revealed that at least for a decade, and I'm quoting directly from the report here, a small group of Steinhoff Group former executives and other non-Steinhoff executives led by senior management structured and implemented fictitious and irregular transactions, and they misrepresented profit by about 100 billion rand. And this resulted in a catastrophic failure of corporate governance because the public harm was also significant. And what I mean by that, for example, was in South Africa, 948 pension funds were invested in or exposed to Steinhoff. And as a result of the fraud, the company lost 98% of its value in 2 years. So people who had invested in this and their pension funds were negatively affected. This case is ongoing. It's carrying on for quite a long time with the FSCA investigating. And then the last bit that I'm going to speak about is just to highlight how we are moving away from traditional D&O risks where in previous years, it may have been limited to only company liability that directors and officers would have faced. But now we look at an ever-changing regulatory environment where compliance has become a big thing that we all need to adhere to. And falling short on this could result in serious repercussions. Then we've got governance is also tied in with the regulatory aspect. Then we've got climate change, and I think that this is very interesting because directors and officers are now facing increasing risks related to climate change, potentially leading to legal and financial liabilities. And this stems from their fiduciary duties to act in the best interest of the company. For example, they need to adhere to the provisions outlined in the National Environmental Management Act, which states that directors are jointly and severally liable for any negative environmental impact caused by the company, including pollution or degradation. The next one is employment. So with increased personal accountability and people raising issues of toxic workplaces, directors are increasingly exposed to claims related to the risks, ethics, and culture of a company. This includes allegations of sexual misconduct, bullying, or discrimination, which have been on the rise in recent times. And then the last one that I want to speak about is social media. The rise of social media has put directors and officers at more risk as well because people can just post anything on a public forum without any kind of justification. And unlike a formal legal process where the aggrieved party would need to prove their loss, social media makes immediate judgments and reputations can be destroyed overnight. Also, inappropriate sexual and racial comments have led to a number of D&O claims over the years. So these are just a few things to look at in terms of directors and officers' liability going forward and the changing legal landscape. Thank you.
Thank you, Sadia. Very informative. I think it's interesting that obviously the world is an ever-changing place. Sadia mentioned obviously the fact that now that social media has such an impact on the global landscape, companies are operating in a far wider parameter than ever before. And obviously climate change is an interesting point because you've got conflicting viewpoints from the American president who thinks that climate change doesn't exist to a lot of markets and professionals and scientists who obviously do believe that climate change is a real factor in the market. But obviously all these have an impact on directors and officers in terms of their responsibilities. And I think obviously as Sadia has mentioned there, the overreaching situation in most countries is that there is a Companies Act in place that actually drives the requirement for D&O cover and the requirement on the directors and officers. And I think from a global perspective, what's better to talk around than Clyde & Co, who are a well-respected law firm operating in a global market offering local expertise in the areas in which they operate. And for that, I'm going to hand over to Andrew Njau in Kenya and his team. Thanks, Andrew.
Thanks, Wayne. Good morning, everyone. My name is Andrew Njau, a senior associate here at Clyde & Co Nairobi office. Clyde & Co is an international firm, as Wayne had mentioned. We are in across 120 countries, and in Africa we're in strategic places. In North Africa we're in Egypt, Cairo. In East Africa we are in Nairobi, Kenya, Dar es Salaam, Tanzania, and in West Africa we're in Ghana, and in South Africa we are in Cape Town and Joburg. As I mentioned, we are very strategically placed. We have expertise in corporate commercial, dispute resolution, and most importantly in insurance law. We have advised numerous clients on insurance policies, settling in insurance claims, and now advising on D&O policies. Yeah, so turning towards D&O, we thought it would be prudent to discuss duties and responsibilities of directors and officers, specifically here in Kenya. So in Kenya, our main governing act for companies is the Companies Act of 2015. In that act, it sets out duties and responsibilities of directors, and failure to abide by these duties and responsibilities, the director is liable to be either fined, prosecuted, they can be disqualified to serve as a director for numerous duration of time, around 5 to 15 years, and also most importantly they could be personally held liable. There's an interesting case that I was reading when I was preparing for this presentation. Kenya Bus Service Limited and 4 others versus PKK and another. It's a 2017 case, and Kenya Bus Service Limited is one of the leading bus companies in Kenya. The directors in that company sold one of the buses, but that bus was involved in an accident. In that case, the Kenyan courts lifted the corporate veil and held the directors personally liable. As you can see, those penalties can be quite severe if the directors are involved in unlawful or illegal conducts, or if the company is insolvent and the directors transact. So moving on to the duties and responsibilities of directors. The first duty under the Companies Act is that the directors should act within powers. What ideally that means is that the directors must abide by the constitution of the company. The constitution of a company is the shareholders agreement, articles of association. So in discharging their duties, they must be guided by those provisions in those governing documents. The next duty is to promote the success of the company. What this ideally means is that they must act in good faith, promote the well-being of the company. We all know that directors and officers, they'll be making decisions when they are in board meetings, when they are passing board resolutions. They must look at the long-term effects, or rather the long-term decisions of that decision. They must look at the well-being of the employees. They must foster good business relations with customers, suppliers, so that they can promote the success of the company. The next duty is to exercise independent judgment. Ideally, what that means is that they must not be biased when exercising their decisions. They must not be influenced by other third parties when they are making their decisions. The next duty is duty of reasonable care, skill, and diligence. This is basically they must act with the standards of a reasonable, diligent person. So let's say, for example, and if they have more skills, they must exercise the skills of that particular person. For example, if the director is a CPA, is an accountant, or the director is a lawyer, as myself, they must exercise their duties, that of a lawyer or that of a CPA. Basically, they must use the skills that they ordinarily use in exercise of their duties. The next duty is the duty of confidentiality. As the word suggests, directors will come into certain confidential information, and they must not use that confidential information for their own personal benefits. That ties to the next duty, which is to prevent conflict of interest. We know well that directors, the CFO, CEO, they might be directors or they might be engaged in other businesses. What this duty places on the director is that they must not be conflicted. They must only act in the best interest of that particular company. However, we are left to the fact that, as I mentioned, directors, they could be directors in other companies. The Companies Act places an duty on the director to declare such interests so that they're not counted in the board decision. The next duty is not to accept benefits from third parties. I think this is self-explanatory, not to accept benefits. The next thing is failure to abide by these duties that have been set out in our Companies Act. There are certain penalties that have been indicated in the Companies Act. The first one, as I mentioned, is being disqualified as a director. Our Companies Act places severe disqualification, 5 to 15 years, depending on the severity of the action. Let's say, for example, failure to file returns, acting improperly, acting illegally, or rather acting with fraud. You could be disqualified as a director. You could also be removed from office. This is even if you have an employment contract, you have the shareholders agreement indicate that you'll serve as a director for a particular time period. However, you could be removed by an ordinary resolution if you act in contravention with the Companies Act. Also, as well, you could also be personally held liable for the company debts. This is if you act fraudulently, improper, acting when the company is in the process of being liquidated or being dissolved. As I mentioned in that previous case, those directors were personally held liable. Also, that transaction could be set aside. What ideally that means is that it's as if that transaction wasn't entered into. Yeah. Nextly, I think it's important now we'll move to discuss some of the examples of cases where directors were personally held liable, and it also touches on the liabilities of directors and officers. At this point, I'll invite my colleague Constance to talk about those cases. Thanks.
Thank you, Andrew, for that introduction. Good morning, everyone. My name is Constance Odiero, a senior associate at Clyde & Co. Nairobi office. I work together with Andrew. I'll take over from where Andrew left. And based on what Andrew has presented, then it would mean that a director, as long as you do your duties, you comply with your responsibilities, you don't go outside the mandate, then you are good to go. You are protected, right? But do you know there are instances where now that doesn't apply? Let me start by saying that the general rule in Kenya and most Commonwealth countries is that directors are protected. There's a corporate veil protecting directors. So if you're going after a company, then you sue that company. The directors are behind that veil. They can't. You can't go after the directors. And this rule is, as I said, in Kenya and Commonwealth countries, it's what we call a separate. It's a principle rather than a company law, where a company is considered a separate and distinct legal entity that is capable of suing and being sued. That means if you have any issues with the company, you sue the companies, you don't go after the directors, meaning the directors are protected. But then what's the essence of the D&O policy? And that's where I'm going to start talking about why do we need the D&O policy. There are instances where the director, a director or a senior officer of the company can be held to be personally liable, and that is where the D&O comes in, why it's important to take it out. So I'm going to discuss 4 such scenarios where directors and senior officials have been held to be personally liable. The first such scenario, this is in the Kenyan context, where a director has been held to be personally liable in relation to personal guarantees in finance agreements. Nowadays, we are seeing more and more financial institutions such as banks insisting upon a company taking a loan, we are seeing banks insisting that directors have to take personal guarantees. I think this has stemmed from the practice where you see a bank offers a loan to a company, the company defaults, the bank goes after the company is broke, it's being wound up, and all sorts of things. So, the banks or financial institutions end up losing the money, or it's a stretchful process before now the company, the insolvency process, you have to take the company through insolvency to at least get back some of the monies owed, and most times you don't even recover everything. They have to follow the insolvency law when it comes to getting back the dues. So in such cases, we are seeing more and more banks and financial institutions deciding to be smart about it. So they're asking companies to sign, the directors of companies to, and also senior officials, not just directors, to sign personal guarantees, meaning that in the event the company defaults in paying back the loans or whatever financial instrument has been taken, then the banks can go directly after the directors and senior officials. And there's an interesting case that is there in the slides. You can see Barclays Bank versus Network Source Limited and two others. The two others are directors of the company. So Barclays offered a loan to Network Source. Network Source defaulted. So in this case, Barclays decided to go after the two directors before even going after the company. Yes, it sued the company, but it also went directly after the two directors of Network Source. So among the things that the court considered was whether, and this is what the two directors were saying, that Barclays should have gone after the company first, determined that the company does not have any funds, then now come after the directors. But Barclays was of the view, you have signed personal guarantees, so I might as well come after the two of you. And then what the court held that Barclays was right in going after the two directors because they had signed personal guarantees that bound them in the event the company is unable to pay. But interestingly, also the court emphasized that Barclays didn't actually even have to go after the company, Network Source. Barclays could have just gone straight away after the two directors in their capacity, having signed the personal guarantees, and they would have been held liable. So that is one of the scenarios, and that is why it's important for directors and officers to have a D&O policy. And another scenario where we are seeing directors and senior officers of a company being held liable is in the event there is a company has been sued and judgment has been entered against the company. So we have a decree, the person who's with the company has been successful. There's a decree against the company, and the person now wants to execute, to realize the decretal sum. And then in that instance, you find out the company has no assets. In such a scenario, the courts in Kenya have that then the directors, the corporate veil can be lifted and the directors behind the company can be revealed, and the person who has the decree can go after those directors or senior officers. So in this particular case, the one we cited, Jaden Limited versus Bradley Limited, the Bradley sued Jaden sued Bradley for whatever it is, and then in the end they got their judgment in their favor, so they went to execute against Bradley, only to realize that Bradley did not have any assets. And but thankfully they had evidence that the directors of Bradley, as the case was ongoing, that the directors of Bradley were seen, there was evidence that those directors were selling off their assets, taking them to other jurisdictions where in the event that Jaden was successful, they would not be able to realize the judgment sum. So using all this evidence, Jaden went to court with an application saying, no, clearly in this instance, these directors are acting fraudulently. Could you please, can I get an order where now we are holding the directors personally liable? And in that case, the court agreed with them because Jaden Limited was able to prove that the directors of Bradley were engaging in fraudulent activities such as transferring the assets, and some directors were even attempting to leave the country to frustrate the execution of the decree. So in short, in such an instance where a person is able to prove that, yes, I have this judgment against the company, but unless you help me, it's going to be a paper judgment. So I need you to lift the corporate veil so that the directors are held liable. But most importantly, that person or the party would have to prove that these directors were engaging in something fraudulent in order to frustrate the judgment to enable the person not realize the judgments. Then definitely they would be allowed to go after the directors, and the directors would be held personally liable. Now, in another instance, an interesting one, a very interesting instance, we are seeing more and more cases being lodged being lodged with the Office of the Data Protection Commissioner, where there have been breaches. So in this particular case, we are seeing a decision was delivered in 2024 where the Office of the Data Protection Commissioner, the Data Commissioner, held that a director can be held personally liable for data privacy breaches by a company organization. In the case we have cited there, Office of the Data Protection Commissioner Complaint 1099, that is John Thuo Kamau versus the Board of Kenya Motorsports Federation and Maina Muturi. So John Thuo Kamau is a director of the board of Kenya Motorsports Sports Federation Limited, and so is Maina Muturi. So John Thuo and his wife decide they want to go watch Formula One in whatever country that was. So they write to the board and to Maina Muturi, who is also a director, and say, hey, my wife and I want to go watch Formula One. Is that okay? The board says that's fine. Then John proceeds to provide their private information on the passport details for him and his wife to the board and to Maina Muturi. The next thing John knows, weeks later, he's being forwarded an email where his details and those of the wife have been shared with everyone. So John decides to take the board and Maina Muturi to the Office of the Data Protection Commissioner and says, hey, there's breach here, my private data has been shared with people, so I need some recourse. So the case goes on, and in the end, the data commissioner agrees with John Thuo and the wife and says the act of Maina Muturi, that is the second director, the second respondent, the director, having shared that information in his capacity as a director of Kenya Motorsports Federation did not his liability did not just latch on the company. The fact that he is also a director meant he would also be personally liable. As much John, because Maina Muturi was alleging that he was sharing that information in his capacity as a director, and therefore it is only the board of Kenya Motorsports Federation that should have been held liable if at all there was a data breach. But the data commissioner disagreed with him and said, yes, you're doing this in the capacity, but also as a director, you are personally liable. So in the end, the data commissioner decided that both the board of Kenya Motorsports Federation and Maina Muturi were both jointly and severally liable. That means Maina Muturi was also held to be liable in his personal capacity. And on to the fourth instance where we have seen a director being held liable is for environmental law breaches. And for this one, we have the Environment Management and Coordination Act. And I'm picking this up from something that Sadia said. We are seeing more they're moving the D&O policies towards what's currently happening with the world. And we are seeing more happening in the environmental sector where now D&Os are becoming very important. So that would be the same scenario in Kenya where we are seeing directors are being held personally liable for environmental law breaches. Specifically, our act, the Environmental Management and Coordination Act at Section 145(3), is very specific that an official of the company, such as a director, a company secretary, or any other senior official can be held liable for any offenses under the acts committed by a company. So should a company be found guilty of any environmental breaches, pollution and all that, then a director can, or a senior official can be held to be personally liable. And those are the four scenarios that we find in Kenya. where directors and senior officers are being held personally liable. I would say that Kenya may not have advanced as much as we're seeing in South Africa, all those other areas where Sadi had pointed out, but I believe we are going through, we will get there. The various different sectors, we are seeing more and more directors being held personally liable, and why D&O policies are very, very important. So I believe that is it from my end, unless there are any other questions. There's a slide there containing our contact details and how you can reach us to provide you more details on DMOs. I think I'll pass it back to Wayne.
Hi, thanks, Constance and Andrew, for that. I think what's very interesting is obviously in most, whether talking through Sadia's presentation or the one from Andrew and Constance, is that in most countries there is as was mentioned, obviously a Companies Act that overreaches all the activities of directors and officers of companies, but also you've got very similar acts in terms of the Environmental Act, Protection of Privacy Acts, etc. And the responsibilities these days of directors is so much wider than it ever was before. In the past, it was just a case of you did your job, you ran your company, and if you made a profit, you were doing a good job. Now you've got all the due diligence issues, your environmental responsibilities, your privacy protection, your social media, and it's made it very onerous on directors to actually operate in a fast-moving and constantly changing legal market. And that's I think, reflects on the importance of D&O cover, and the fact why there are perhaps over 700 people on this presentation this morning to show the indication of how important this actually type of cover actually is. I'm going to hand over now to Sipa and Nadia, who may have some Q&A stuff from from the panel out there, if you'd like to continue.
Hi, everybody. So I have a question for the panel. So, topping the list everywhere in the world has been cyber. So I was just wondering, on your side, how seriously are the C-suite taking cyber? And have there been any enforcement notices or fine issued against directors for failing to comply with ensuring that their environments endorse good cyber hygiene and incident response plans? What has the atmosphere been on that side?
Andrew, do you want to take that question?
Yeah, thanks, Wayne. How seriously are we seeing the C-suite taking cyber on your end? I think from a Kenyan perspective, we are seeing now most boards and most C-suites being quite particular, and rather, for example, on data protection, they're quite keen to actually be compliant from a Kenyan perspective. We're seeing more policies being drafted. We're seeing most companies being compliant, so that they aren't in a scenario where there are fines. We are preparing certain policies for clients. We are seeing even more companies now, or rather, subscribing and taking on D&O policies. Yeah.
And Sadia, perhaps from your perspective and from a South African point of view, I mean, are you seeing also the same situation occurring from a South African and other markets that we operate within?
So the cyber matters that we get are not all relatively straightforward, where there are different inferences that can be drawn in terms of where the liability may have occurred. For example, it could be that the directors didn't have a proper regulatory framework in place, which included cybersecurity and network posture, and this wasn't, properly implemented within the company, then they definitely could be held liable. And that is part of the developing trends that we are seeing going forward with this type of liability.
Thank you. And then Nadia and Sipa, are there any more questions from the audience out there?
Okay, there's none from the audience, but I actually do have a few questions for the panel. And once again, it's taking us back to cyber. And it's great to know that there has been an uptake on companies getting the policies and actually prioritizing their cyber hygiene in their environments. I just want to know, in terms of the types of fines, what fines have been issued, if any? What are we looking at? Because I think last year or the year before last year in South Africa, there was a fine issued in the region of 5 million. So what types of fines are we seeing around Africa? Do they actually issue these fines?
Andrew and Constance, do you want to take that from a Kenyan perspective?
From a Kenyan perspective, I would say just what you're saying, Nadia, we are seeing the fines in the range of millions, from hundreds of thousands to millions. And yes, the fines are being issued, and I believe the companies are paying. So I want to believe in Kenya that the issue is being taken more and more seriously. You see, unlike when I was presenting, maybe I should have mentioned, unlike the other instances where we are seeing personal liability was more through case law, but this one is actually set in the act. So the directors, they can't allege that this has to go through the court and all that. From straight away from the beginning, they know this is in statute. In the event they don't comply, they'll be held personally liable, and these are the fines. The fines are set out in the act. So yeah, they range from hundreds of thousands to millions. And yes, to answer your questions, yeah, we are seeing companies paying, but also we are seeing more, as Andrew said, more and more taking the D&O policies, so that it lessens the burden on them having to pay out of pocket. And also we are seeing more companies complying and coming up with policies and ways in which they can just comply with the act, so that they don't get to where they're being fined.
Okay, thank
Thanks,
you for that,
Constance.
Constance.
Nadia, another question you have?
I see that there has been one from Bernard, Velma Bernard, in the Q&A. Just wondering how the insurance industry is creating awareness of the importance of D&O cover with the younger generation of company directors. From our opinion, Kenyan colleagues, what is the trend on the ground? What's happening on the ground there around creating this awareness? Anybody feel free to comment on what's happening on the side as well?
Interesting. I think I'll take that one. For the younger generation of directors, I think you see the DNO policies has been here for a while. It's not something new. We are seeing now more companies doing a bit of sensitivity, or rather a bit of training for the directors and even some of their staff, so that now the senior managers know that there is this product available in the market. Hence why now iTOO is doing this training. I think it's more of trainings that have actually been done here in Kenya, and we are seeing more trainings being done so that the directors and senior managers are aware of this. Yeah.
Thanks,
Yeah.
Andrew. Yeah.
And I think from a South African perspective, when the younger generation go into these roles, the positions that they hold are more fluid as compared to previous times, because now they are aware that there are other trends going forward that they would need to be responsible for in terms of their company. And with the legislation changing as it is, and the introduction of other pieces of laws coming into play, for example, the Cyber Crimes Act, and having regard to the Environmental Management Liability Act, all of those things they would need to be aware of depending on the scope of where they are in the company, what the company activities actually entail. And there's also been a lot of cases recently that have highlighted that directors need to be aware of these things going forward.
Thanks,
Right,
Sadi. I
thanks
think
for this.
it's very true that the market in which we operate and companies operate is very fluid, and responsibilities are changing all the time. Nadia, another question you have there?
I see that there has been one from an anonymous guest. If the directors make a decision without following due process, which then negatively affects some shareholders financially, can these losses be claimed from the directors responsible?
So, Andrew, from a Kenyan perspective, your thoughts on that one?
Interesting. I think that touches on litigation, but yes, if it can be actually proved in court that they didn't abide by now their duty, either they did not promote the success of the company, either it wasn't in the benefit of the company, and I think it it will be interesting to see if there is case law on that. But I think it's a good scenario to actually go to court. They could be found liable for that.
Just to assist Andrew, yes, they have been cases, if I understand the question right, where directors don't follow due process and their actions end up affecting the shareholders. So in that instance, a shareholder is free to go to court and file what we refer to as a derivative claim. So the shareholders are protecting themselves and the companies against the actions of the directors. And there have been very many cases, and the directors have been held to be liable. And in such an instance is what would also lead to a director being personally liable.
Thanks,
Okay, thanks
Constance.
for that, Andrew and Constance. So I've got another question, and whilst we've touched on cyber, climate change and ESG is also very, very topical. And we do know that directors in Kenya are now expected to actively promote and monitor social responsibilities of companies, considering those environmental, social, and governance factors. We're taking into regard the issues impacting Africa, like biodiversity loss and deforestation. What has been the mindset around the mindset of the C-suite around compliance with ESG and climate change, and what steps have they taken to ensure that they've hopped on this? We're going to comply and do our best with regards to ESG and climate change.
I think I'll take that one from one Kenyan perspective. Good question on that. Yes, on ESG, I think what we are seeing from the onset is that most companies are actually doing due diligence on themselves. They want to know from an ESG perspective, are they compliant? Have they complied with corporate governance? Have they complied with environmental laws in all their decisions? We are seeing now from this side, from a corporate commercial perspective, we are doing more and more DDs on companies from an ESG perspective and advising them to be compliant, and also advising him on the actions that they can take so that they can be compliant. Yeah, that's it from a Kenyan perspective.
Thanks for that. Thank you, Andrew. And just on another topical subject, and this is around AI, do you see directors basically establishing ethical frameworks for AI use that aligns with their values and regulatory obligations? What is the legislation or any policies that have been implemented around emerging technologies and AI on your side?
Interesting question on that. For AI, I would say it's still a new concept, and it's still in the infant stage from a Kenya law perspective. There aren't laws that touch on AI, but what we are seeing on Kenya's perspective, the regulator and our Ministry of ICT has come in place with a national AI strategy. It focuses from 2025 to 2030. It drives to ensure that there is innovation and research in Kenya. So I think what we'll see in the future, there will be internal policies that will be drafted for companies. On that, what is just being focused is still on the cybersecurity and data protection. We haven't progressed as much to draft now the AI policies to ensure accessibility now to everyone.
Yeah, and I think that from a South African perspective, or maybe it would apply across Africa as well, due to there not being any sort of formal legislation. And in the absence of that, it would fall on the responsibility of those having oversight on the company to ensure responsible AI use, because there are plenty of open source AI platforms which can be used, sometimes with or without the knowledge of management that are being used by the staff. And I think that it's imperative that those kinds of policies or frameworks within the company are properly structured just to provide guidelines as to how these can be used, because you wouldn't want to put something out there that has been derived from AI purporting to be the idea or the stance of the company, and then there are legal repercussions which follow thereafter.
Thanks, Sadi. I think you're quite right in that respect. I think AI has actually changed the landscape in which we operate, and it's actually a fast-moving technology that I think we're struggling to keep up with, to find out these days what is real and what is actually fake out there. Nadia, any other questions from your side?
I'm very interested to know, because we've in South Africa, we've had a lot of whistleblowers, right? And unfortunately, whistleblowers have not always been protected. Andrew, Constance, on your side, is there a whistleblowers policy? If there is, what is the protection that they are afforded under the law on your side?
I would say I would not want to give misleading information, but I'm not sure about whistleblower policy. What I've seen is for individual organizations, but as to whether there's legislation or anything, I have not seen. I've seen individual organizations and companies come up with policies that have been implemented, and in my side now as a dispute resolution lawyer, I've seen where, people have gone to court over such policies and they've been upheld. So that's the little I know. As to whether there is a legislation, I am yet to see one. But individually for organizations, yes, they do exist. They have been implemented by companies. They're effective. I know of about 2 clients that are effectively using their policies, and their policies are giving them results. And that's what I would say.
Yeah, right, Constance. We actually don't have governing law on whistleblowers. We don't have a whistleblowers act in Kenya. I know there was a bill that was being considered some time back, but it hasn't yet been enacted into law. So what we are seeing is more companies. The obligation is on the companies to ensure there are safe practices. There are safe safe avenues for whistleblowers to share information, and they won't be unfairly prejudiced.
That's good to know, because it's reassuring to know that there is this mechanism which does allow people to, voice what they need to, and not be prejudiced. And I just have one last question. Any tips from the panel in terms of, for directors, in terms of good governance, to ensure that they're compliant, and, what should they be focusing on? What key practices should they be focusing on?
Andrew, do you want to sort of comment on that one from a Kenyan perspective in terms of main focus areas for directors to be aware of or look into?
I think we've addressed it on a high level. I think at all times is to be compliant with the law, be compliant with the duties, be compliant with corporate governance, and also be compliant with their internal policies. And as always, we're always happy to help on that. Yeah.
Perfect. Thank you. Nadia, any other questions from your side?
Nothing from my side, and I don't think anything further has come through from the chat, so all clear on my side.
Perfect. All right. Well, guys, just to say thank you from our side, from an I2 perspective, for Sadia and Nadia, and also obviously to Clyde and Co, to Andrew and Constance and the team there. We really appreciate the insights. I think there's a large element of overlaps between the different areas in which we operate that are fundamentally the same. But I think directors and officers, the fact that there are so many people on this talk is a very hot topic at the moment. And all I can say to everyone out there in the world, whatever else, who'll be listening to this presentation, thank you for your commitment and your interest, and hopefully we can share some more insights as we go forward. Thank you.
Thank you all.
Thank you.
Thank
Thank
you.
you, everybody.
Bye.
Thank you, everyone.